The fire chief didn't look at me when he said it. He stared at the smoking remains of my corn barn like he was afraid the ashes might answer before I did. The structure was gone. Not damaged. Not partially burned. Gone. 20 years of seasonal harvest storage reduced to blackened beams and twisted metal. I stood there in boots still dusty from a morning inspection, trying to process how a locked, insured barn on private land somehow caught fire at 3 a.m. Then I saw her, HOA Karen, standing just beyond the tape, arms folded, watching, not shocked, not upset, satisfied. That's when I knew this wasn't an accident. I live outside town limits, on acreage my family has owned longer than the HOA has existed. I don't attend their meetings. I don't pay their dues. I don't follow their rules. And that's always bothered her. She's complained about my tractors, my fencing, the smell of fertilizer, the height of my corn, even the direction my driveway curves. Every time, I reminded her calmly that I wasn't part of her association. Every time, she smiled and said, "We'll see about that." 3 weeks before the fire, she sent a notice claiming my barn violated HOA fire safety standards. I ignored it. A week later, she came to my gate with 2 board members and a printed violation sheet. I told them again they had no authority here. Karen leaned in close and whispered, "This eyesore won't be standing much longer." I thought it was a bluff. I was wrong. The fire investigators said there were accelerants. The deputy said it was arson. Karen said nothing. She just watched, nodding slightly when the investigator confirmed the burn pattern was intentional. When the deputy asked if I had disputes with anyone, her head turned just enough to make sure I noticed. Later that afternoon, while the ground was still warm, she posted on the HOA bulletin page that unsafe rural structures had finally been addressed. She called it a community safety win. Comments praised her leadership. Someone even thanked her for taking decisive action. I stood alone on my land, staring at what was left, realizing something important. This wasn't about rules. This wasn't about safety. This was about power. And Karen thought she'd just proven she had it. What she didn't know, what no one in that HOA knew, was that I had spent my entire professional life inside courtrooms, not cornfields. That my name didn't just appear on land deeds. It appeared on federal opinions. That I wasn't just a landowner. And that burning my barn wasn't just property damage. It was a federal mistake. Karen didn't wait long to escalate. 2 days after the fire, before the insurance adjuster even finished documenting the damage, I received a certified letter from the HOA. It claimed the barn had been a known hazard, and that its destruction eliminated a compliance issue. They demanded reimbursement for community enforcement expenses. $5,000. The letter was signed by Karen herself. I called the number listed. She answered on the first ring. Her tone was cheerful, almost warm. She said the HOA had taken initiative where the county failed. She said I should be grateful no one was hurt. When I asked why her notice appeared online hours after the fire, she laughed and said, "Leadership requires preparation." I reminded her, again, that I was not a member. She told me membership wasn't optional anymore. According to her, my land fell under expanded jurisdiction. I asked for documentation. She emailed a blurry map with my acreage crudely highlighted. No seal. No signature. No authority. Then she made the mistake most people make when they think they've already won. She threatened me. She said if I pursued this, the HOA would report zoning violations, environmental concerns, and safety hazards to every agency that would listen. She said she had friends in county offices. She said courts favor communities, not isolated individuals. That last line stuck with me. The next morning, a county inspector showed up. Then a fire marshal. Then an environmental compliance officer. Each one polite. Each one clearly responding to complaints. Each one surprised when I calmly handed over permits, approvals, and compliance certificates dating back decades. The visits ended quickly, but Karen's confidence only grew. She sent another message to the HOA group celebrating pressure applied. At the end of the week, I received a summons. The HOA was suing me for obstruction, noncompliance, and interference with community governance. Karen was listed as the primary complainant. She scheduled the hearing locally, in a small municipal court. That's when I realized she truly believed her own myth. She thought titles mattered more than law. That noise outweighed substance. That intimidation replaced jurisdiction. I attended the hearing alone. No lawyer. No entourage. Karen arrived with 3 attorneys and a binder thick enough to impress anyone who didn't read carefully. She smirked when she saw me. She whispered something to one of her lawyers and laughed. The judge asked her to proceed. She spoke for 20 minutes about safety, authority, and community standards. She described me as uncooperative, hostile, and negligent. She described the fire as preventative enforcement. When she finished, the judge turned to me and asked if I wished to respond. I stood. I introduced myself by name only. No title. No explanation. Then I asked a single question. Before we continue, could we clarify whether this court has jurisdiction over federally owned agricultural land? The room went quiet. Karen stopped smiling. The judge frowned and asked me to repeat the question. I did, slowly this time. Karen's attorney objected, claiming delay tactics. I asked the court for permission to submit documentation. The judge allowed it. I handed over a thin folder. No dramatics. No speeches. Just paper. The first document established that my land was enrolled in a federal agricultural preservation program. The second showed easement protections limiting municipal authority. The third outlined jurisdictional exclusions tied to federal land use oversight. Each page was stamped. Each was current. Each contradicted everything Karen claimed. The judge leaned back and began reading. Karen whispered urgently to her lawyers. One of them flipped through their binder, confusion spreading across his face. Another pulled out his phone and started typing. Then the judge looked up and asked me a question Karen never expected anyone to ask me. He asked if I served in the judiciary. I answered honestly. I said yes. I said I was a federal judge currently on senior status. I said I hadn't mentioned it because it wasn't relevant until jurisdiction was challenged. I said I was there as a landowner, not a title. The courtroom froze. Karen's face drained of color. One of her lawyers actually stepped back from the table. The judge cleared his throat and called a recess. During that recess, something interesting happened. Karen stopped talking. Completely. Her attorneys did all the whispering now. Papers moved faster. Phones rang. Confidence collapsed into damage control. When the hearing resumed, the judge dismissed the HOA's claims for lack of jurisdiction. He warned them about frivolous filings. He advised them to seek counsel familiar with federal land authority. Then he looked directly at Karen and said, "You may want to consult an attorney about the fire." She tried to speak. He cut her off. Outside the courtroom, Karen avoided eye contact. Her attorneys walked away without her. I stood on the steps, breathing in the cold air, knowing this wasn't over. But the balance had shifted. That afternoon, I filed a report with the Federal Fire Investigation Unit. I submitted the accelerant analysis. I included screenshots of her posts. I attached her letters. I didn't embellish. I didn't threaten. I let facts do what they always do when given time and authority. 3 days later, federal agents arrived at the HOA office. They seized computers. They interviewed board members. They requested records. Karen wasn't there. She called me that night. Her voice was different. Softer. Careful. She said there had been misunderstandings. She said she never intended harm. She said perhaps we could resolve this privately. I told her I no longer discussed matters involving federal crimes outside official channels. She hung up without another word. That was the moment she understood. The barn was just the beginning, and consequences don't burn down with the structure. The investigation moved faster than Karen expected. Accelerant sourcing tied directly to a purchase made using an HOA credit card. Security footage from a nearby supply store showed her unmistakably clear, loading containers into her vehicle. Text messages recovered from HOA devices discussed handling the barn issue permanently. Karen was arrested on a Tuesday morning. No sirens. No spectacle. Just handcuffs and a federal badge. The HOA issued a statement claiming ignorance and cooperation. Board members resigned within hours. Lawyers stopped returning calls. Insurance paid out for the barn. Then subrogation kicked in. Civil claims followed. The HOA's accounts were frozen pending investigation. Special assessments were halted. Residents panicked. Meetings were canceled. Karen's attorney tried to negotiate. He suggested restitution and community service. The prosecutor declined. Arson on federally protected land doesn't negotiate easily. At the arraignment, Karen looked smaller. Not physically, but internally. The confidence was gone. The certainty evaporated. She avoided my gaze as charges were read. I was asked to testify. I did. Briefly. Factually. Without emotion. I described the notices. The threats. The fire. The posts. I didn't mention fear. I didn't mention anger. I let the record speak. The judge set bail conditions. Karen was prohibited from holding any HOA position. Prohibited from contacting me. Prohibited from accessing HOA funds. The community reacted quickly. New leadership was installed. They issued a formal apology. They acknowledged overreach. They requested mediation. I declined. Instead, I requested something simpler. I asked for formal acknowledgement that my land was not under HOA authority. I asked for public correction of the statements made. I asked for reimbursement of legal and investigative costs. They agreed to all three. Construction began on a new barn that fall. Larger. Safer. Fully compliant. Federal agents inspected it themselves. Sometimes neighbors stop by and ask why I didn't tell anyone who I was sooner. I tell them the truth. Power only works when people misuse it. Law works whether you announce it or not. Karen learned that too late. She thought fear came from titles and threats. She forgot where real authority comes from. And she forgot that burning down a man's livelihood doesn't make him powerless. It just reveals who already was. By the time sentencing arrived, the story had spread well beyond the HOA. News outlets framed it as a cautionary tale. Legal journals discussed jurisdictional abuse. Community boards across the county quietly revised their enforcement policies. Karen accepted a plea. Federal arson. Abuse of organizational authority. Wire fraud related to HOA funds. She received a sentence that included prison time, restitution, and a lifetime ban from serving on any governing board. The HOA dissolved 6 months later. Residents formed a voluntary association focused on maintenance, not control. Participation dropped. Conflict disappeared. Funny how that works. I finished the season's harvest without issue. The new barn held more grain than the old one ever did. Insurance covered the rebuild. Restitution covered the rest. People still ask if I regret not stopping it sooner. I don't. Systems reveal themselves under stress. So do people. Karen believed rules were weapons. She believed intimidation replaced law. She believed fear was authority. She was wrong. Authority doesn't shout. It doesn't threaten. It doesn't burn. It waits. And when it moves, it does so quietly, precisely, and permanently. I still live on the same land. Still outside HOA boundaries. Still uninterested in meetings. But now, no one questions where the line is drawn. Because it was written long before Karen tried to erase it with fire.